Marta is our 2021 business law section leader, and I'm going to turn it over to Marta to begin the program. Thank you, Marta.
Thank you, Anne, and thank you to Roger, Luis, and Mark for letting me lead them to give this presentation today, and welcome everybody on behalf of the business law section. And thank you for all the support from the family law section for putting this event together. We were very excited to put something out that is a bit interdisciplinary, and hope that you will learn just as much as I will, because I don't know anything about what they will be talking about. So I'm going to be the useful idiot and ask all the questions everybody is too shy to ask. Thank you so much. I pass the baton now to Mark Hilliard, who was instrumental in putting this together with me. Thank you.
Thank you, Marta. And I would also thank the litigation section for its help as well. At this time, I want to thank our panelists for being here. Roger Brothers is a distinguished business law attorney from Brothers Smith LLP here in Walnut Creek, and Louis Montes is a distinguished family law attorney from the law offices of Louis Montes on Alameda, but he's out here quite a bit as well and very involved in our bar. So thank you for both of them and to both of them. And I'm going to turn it over. We're going to start with something very preliminary. What is the difference involving a company where both spouses are involved in working in the company versus a company where you have one spouse involved in the company and one spouse not involved in the company when you're in the setting of a divorce? So with that, let me turn that over and pose that question first to Roger for his input on that.
Well, first of all, welcome everybody, and thanks, Mark. So it's a different setting. If you have a company where you have both spouses actively involved in the business and presumably both spouses owning equity, either shares in a corporation, membership interest in an LLC, or partnership interest in a partnership, your partnership agreement is going to dictate a lot of those relationships. So in terms of how you manage, how you vote, etc. If you only have one spouse in the business, now it's a different situation where there's only one spouse that's been primarily in the business, operating the business. And what are the rights of the out spouse in regard to decisions, information, etc. So that's very critical at the outset to determine where that is and who has what rights within the business. In even situations where you have an out spouse, you need to determine how the interests are held. So that is, are they held each individually? Do they own shares in their individual name, even though the spouse isn't necessarily participating in the business? Are they owned jointly and severally, jointly, by them? That is, that the husband and wife as community property or right of survivorship, etc. Are they held in a trust? And if they're held in a trust, what are the rules of the trust with regard to how that trust is administered? Is it both trustees acting jointly? Is it a single trustee acting on behalf of the trust? Because all those will impact the decisions and the management of the company during the course of the dissolution proceeding.
And Louis, did you have anything you wanted to add to that from a family law perspective?
Yeah, so first of all, I want to thank everybody that is attending. Thank you very much. Big, huge kudos to Mark. He has been the person that has been essentially putting this all together. Mark, thank you very much for all of the help that you gave me to coordinate with this. With regard to my practice, very quickly is, yes, I did start in family law way back when I was a really young attorney in 2008. And I've since switched mostly to transactional. And while I do family law, because Mark said I'm an expert, I'm certainly far from an expert, but being a transactional attorney and representing a number of businesses, on a rare occasion, I get a divorce where the business is. And my practice now is almost exclusively representing in family law a divorce where there is a family law owned business, except for my pro bono stuff. So the thing that I wanted to add to Roger's presentation is that when the family law code kicks in, sometimes, depending on which side you're representing, the interest, how they're held in the entity or the trust or the sole proprietorship are greatly affected by the community property model that we have, specifically in division, because that's what we're talking about. That's all that I wanted to add. If there's any questions, we'll take them on that.
Yeah, and let me ask Roger a question. Is there a difference for an LLC where you have one of the spouses in the dissolution as the managing member versus the other one who is a non-managing member? Is there anything to be aware of when you have that nuanced fact?
Well, as most people know, I mean, LLCs are either member managed or manager managed. If you have a manager managed LLC where management of the day-to-day operations have been delegated to a manager, then you need to go to your operating agreement to determine what is the exact authority of that manager. Some operating agreements are very broad in giving the manager almost exclusive authority to make decisions on behalf of the LLC without regard to any input from the non-managing members. Others are limited in scope in terms of what a manager can do without the consent of the members. So that's the first place to look. You'd have to determine that scope.
Okay. We're going to move from this preliminary discussion into something also preliminary, but a little further down the road, choosing representation. So when a dissolution appears to be imminent, and there's a business involved, Louis, what are the important things to know about choosing proper representation in that fact pattern?
Well, this is the perfect art of practicing law. In what I have observed is that depending on what the goal of the parties are, one really needs to determine whether one is going to, if you're the client, whether you're going to hire, a transactional lawyer, a litigator, which I define a little bit differently than an actual trial attorney, and then the approach that any one of the particular attorneys are going to give, because what I have seen in specifically the business dissolutions is that, unfortunately, the law firm or the attorney drives the agenda to the detriment of their client or both clients and the business by burning through a lot of extra time and effort, when it's many times the real goal should be, as we respect in my firm, is the business of my clients is to make money, not to be litigating or be in court. So that's really important, and it is, excuse me, an art, and it also is important for the particular attorney to be able to, one, adapt to whether or not there is no choice but to get into actual trial mode, even if it's at the very beginning of the engagement, or to be a transactional attorney. And if you're unable to manage that role, to either partner up or less inviting, to hand off the case. In my case, I've handed off matters to bigger law firms who can handle the onslaught that sometimes is necessary. That is really an art, and I found that the attorneys that handle more business and perhaps have business experience in the past are better able to manage for the benefit of their clients. It also goes to the judge. There have been times when it would have been better to go with a different judge, or at least, as we call it, paper the judge that we have now, in hopes that you're going to get a different kind of a judge for this particular case. And that really is an art. I suspect that a veteran expert like Roger probably has more experience than that than I do, but it's very important. Obviously, it's not a procedural legal maneuvering, but it's has to do with the tactics and the strategy of your goals.
And Roger, obviously, one of the ethical concerns, or really, setting aside the ethics, we'll come back to that in a moment. But one of the things you need to do is choose an attorney that fits the sort of the style or the flavor of the case. If it's an amicable divorce, maybe you don't want a hard-nosed litigator. But if it's more, if there are more assets and it's a difficult divorce, maybe you do. Could you speak a little to that?
Well, yeah, and I think a lot of it too depends on where in that process you're being brought in. I mean, I've been in situations where I am corporate counsel and the CEO has now been served with divorce papers out of the blue, wasn't expecting it, and now we're kind of in a scramble to determine exactly what's going on here, because they had nothing, they didn't know what was coming. And then in situations where both spouses were in the business and one is raiding the corporate funds, and what do you do in that situation? And then by the same token, I've been in situations where I've been been brought in to counsel people who own businesses preparing to file divorce. And what are the things that you need to do at that point in time? So it really depends. Obviously, that's a transactional business attorney on the front end there. If you've got a situation where you've got to step in immediately and take action vis-a-vis a spouse who's raiding the corporate funds or doing something along those lines, then obviously you need to bring a litigator in. You need to be able to go in and get that TRO or whatever you need to file to get that stopped. And so I think that really does fit sort of the circumstance of both the objectives of the parties, but also where the case is. Unfortunately, as much as we try and convince the parties that the most important thing here is to preserve this business, that's not always a priority with the combatants, unfortunately.
Good enough. And Louis, I know that there are some ethical considerations representing a family business in the course of a dissolution. Did you want to tackle that and talk a little bit about that subject?
Yeah, I'll make that real short, but I do want to backtrack just a little bit with regard to the when an executive gets served with the divorce papers. One has to be careful, specifically in a marital divorce, of respecting the atros, which are automatic restraining orders on what the parties can do once the petition has been served. And sometimes we get into trouble if the one of the spouses starts disposing of assets, or as Roger said, raiding the corporate coffers. With regard to the ethical issues of representing a family-owned business, the safest bet and the default rule is to clearly communicate to whomever you're talking about whom you represent. Some of us who are inside, outside corporate lawyers, corporate representatives, that we represent the corporation, we have to be expressly clear in communicating in writing always to the person that we're speaking to as to whom we represent. We have to make specifically clear that I represent the company and I'm able to talk to you to some extent, but I am not your attorney. Fill in the details. That will save our bacon more often than not. And the rest really gets down into the briars of the details. But to save ourselves and really to save our clients so that they don't get their feelings hurt by somebody like us whom they have a lot of trust in. I'm sorry, I misstated that. To not hurt the feelings of interested people in the company, if we were to give them advice and not tell them, look, I represent the executive, or I represent the company, and I don't represent you, and you really need to get your own attorney. That in my experience has been where people, the constituents, really get their feelings hurt and can get very adamant about you having overstepped the trust and betrayal that they feel. And I think rightfully so, if we take the shortcut and not specifically tell them. When we're talking to them, we know who we represent, and let them know that. I feel that that's one of the most important things, and we try never to overlook that at our firm.
And it's important to also represent to the other side who you represent in what capacity, whether as an individual or as a president or something like that. I would just add that to what you just said, Louis. Let me ask you, we have a good question for both of you. Is it recommended to obtain a conflict waiver when you're retained, or does it depend on perhaps when in the dispute you're retained? In other words, to obtain a conflict waiver from husband and wife to represent the business. Roger, I'll turn to you first if you have any thoughts on that.
Well, I think if you have an established relationship with the corporation and you've got a retainer or fee agreement that says, hey, I'm representing the corporation, typically you would have some type of conflict waiver among the shareholders. That might not necessarily happen with a husband and wife, but I think it would be a good idea to get a conflict waiver if you're going to continue to represent the company only in that divorce proceeding from them at that point in time. Now, if again, part of that depends on, are both spouses actively involved? Are they both equity holders, et cetera? Because there may be a different situation. And I think also when to Louis' point, it sort of depends. Do you have this longstanding relationship as corporate counsel and everything was fine, and all of a sudden we have this divorce proceeding? Or, as often the case for me, I'm brought in either to represent the corporation post-divorce filing or to represent one or the other spouse in negotiations vis-a-vis the business, either leading up to to dissolution proceeding or in the throes of a dissolution proceeding, because you have very different clients with very different interests. But I agree with Louis that it's very important at the outset to establish who you represent and also who holds the privilege, because we've gotten into some discussions about that and they've been the subject of some motions. Who holds the privilege, who can waive the privilege in each of those various representative capacities.
Very good. Louis, is there anything you wanted to add on the issue of conflict waiver before we move to our next topic? And we're going to talk about valuation next.
Okay. Yes. With respect to waivers, waivers are fine and dandy, and they're really almost certainly any of us who work in contract can draft a conflict waiver. But I think that you said something of getting conflict waivers in advance, and there are some mines, landmines to be stepped on. With I'm not sure if you said that, but if you didn't, I would like to caution people that there are some legal malpractice landmines for us attorneys for advance waivers. And I will reiterate, because it's important and it bears repeating, that the circumstance of what Roger said, that the circumstances change as the matter, the litigation unfolds, and specifically corporate attorney, our role as corporate attorney, the tides can change to where it can get very dicey and tricky, where one has to bring in an expert malpractice attorney to give advice. I have been caught up in that a couple of times when I'm corporate attorney in business divorces. I've never had the opportunity, thank goodness, in a marital divorce. but caution.
Got it. I want to turn next to, we're going to discuss valuation. And I know that obviously this is a pretty interesting topic because there is such a dichotomy between, on the one hand, the way that a business is valued under the corporations code versus how it's valued in the family law code. So I thought, first of all, we could just kind of discuss what some of those differences are by learning how the valuations occur. Roger, let me turn to you first. When valuing, and I understand that for you, this will depend on the form of the business, whether it's a corporation or even within that, an S or a C versus an LLC or something else, a partnership. How generally, if you could speak to how are businesses generally valued within this type of a setting? I understand the family law does its own thing, but how are businesses valued on the corporate level or on the LLC level?
Well, it depends on the valuation that you're asking for. Are you asking for a valuation? There's fair value, fair market value, and there's ongoing concern, there's liquidation value, and that all those, the nuances of each of those are well beyond this presentation. But you need to understand how are you going to value it, for what purpose? And because they have different valuation mechanisms, and you should discuss and agree upon those when you're deferring this to a valuation expert. And what is he or she asked to do? What type of valuation they asked to provide? Now, and also when you're getting into valuations of the business as opposed to valuations of interest within the business. Because if you have interest within the business, we have majority versus minority, and the minority interest is held by someone who does not have an ability to control the outcome of the company, then that you can argue that would be subject to a discount. In a privately held company, you're likely going to be subject to some discount on the basis of lack of marketability. You can't sell that interest. You can't take that to Wall Street or to your broker and say, sell my 15% interest in company ABC. So you get a discount for lack of marketability. And you may also argue for a discount for lack of control. And you can get somewhere between 30 and 40%, depending on the valuation expert, depending on the business, et cetera. So those are things to keep in mind from a business standpoint. Obviously, when you're talking about a family law situation, it might not be as clear. And if you're going to have a situation where you are going to be discounting, I encourage our clients to build that into your organizational documents, whether it's your buy-sell agreement, your operating agreement, et cetera, so that everybody clearly understands that in the situation where we're going to be doing evaluation, we are going to be assigning discounts to those.
Very good. Louis, how are things done on the family side with the juxtaposition of what Roger just said?
So generally in a family law business that's owned, let's say, wholly by the marital community, the code says that each spouse owns 1/2 of it, and assumed to be divided, undividable 1/2 of the interest. Everything that Roger has said is applicable in the family law arena. The little tiny bit of difference that I have seen is that usually in the family law, when we're attempting to reach a settlement, there's a lot of horse trading going back and forth. Not to be flippant, but perhaps generally one of the parties is the in spouse who controls the business, in other words, manages it, and the other spouse is out doing something else and is not as involved in the business. And the difference of opinion and valuation can be very big, sometimes realistically, sometimes not. So you're going to be horse trading. I'll use the following example so that it's flippant and not applicable to any particular case, is that the spouses own a Ferrari and they also own a let's just say a medium-sized construction company. So wife is going to want the Ferrari because husband wants the business, and let's just say it's one of those really expensive $1 million Ferraris, and then husband is going to say, well, no, my business is only worth a lot less than that. So those are the approaches that a family law lawyer has to be a little bit more cognizant of to get a fair deal, you know, within our ethical boundaries and also for our particular clients. Like I think, like Roger said, this presentation really is under the scope of just the valuation of a business. I would like to address one issue that is sort of near and dear to my heart, and that is valuation of law firms. And I wanted to say that the market approach to a law firm, which is where you compare it to other law firms that have sold, is generally not workable for a law firm. And we really could go on a lot about this, but I'll try to keep it really brief. So there's other ways to approach it, more like an inventory. Trust and estates kinds of practices are a little bit easier to value than, for instance, a firm like mine, where we're mostly taking care of businesses and some family law. And the other thing that I don't want to overlook is, as Roger alluded to, we look to the governing documents of a particular business to see how it is going to be managed in a dissolution. And really, that's where we as attorneys, the corporate attorneys and the attorneys that are creating these entities, can really protect our clients or their businesses by drafting and not letting the client, to the extent that we can, take shortcuts in addressing some of these issues that are foreseeable. They may not occur, but they are foreseeable. For instance, as Roger said, who gets to do what in the business at the tail end when we're in a dissolution can really take care of a lot of problems and grief as we're maneuvering these dissolutions.
Very good. All right. Let me ask you this. Did Roger, for personal services businesses, is there anything that's nuanced or that in litigation? Well, actually, let me ask a different question. In litigation, is there, and let me ask this question to Louis, actually. In litigation, when you're in this type of a situation and you're in a dissolution action and you have a family business, are there any litigation tactics that you're aware of that you can use in order to get the court to buy one valuation over the other, or one means or method of valuation over the other? Or do family law courts typically stick to perhaps some type of a formulaic evaluation process?
I am not aware of a formulaic process that is generally used in the family law when we're dividing a business. I will tell you that it has been my experience that, as is classic in our business, is I think that the better prepared party who has a solid expert and that presents their opinion to the judge is going to do better. But then I have found that to be true in our regular business dissolutions. At least in family law, and at least in the judges that I have appeared with, they seem to be sensitive to the fact that one party is going to undervalue it and the other party is going to overvalue it. And to the extent that you as the attorney can manage that perception, you're likely to get more for your side, depending on what you want. I would like to add with that unless you have another question.
Well, let me ask Roger a quick question. Roger, when you're watching, when you represent a business and you're watching the husband and the wife that own the business enter into a dissolution, do you have any, obviously the subject of valuation is well within the ambit of expert testimony. When would be the best time to retain an expert? Is there a benefit to doing it up front versus waiting or waiting?
I'm not, I mean, to be honest, I don't really know if there's a benefit one way or another. It sort of depends what type of divorce it is. This is an amicable divorce, or is it going to be contested? Where are you in the family law process? I don't think there's any downside to getting someone in at the outset early on, because that person can always adjust their, if it's too long and they say, well, it's too long and now we're finally getting to the point where we're dividing assets, we need this updated. It would be a lot easier for that person to come in and update his or her evaluation based on the new information. So I think the earlier the better. And again, I think it's important that you talk with the valuation expert to make sure that they have what they need from you to properly value the business, because the last thing you want is a valuation with a bunch of qualifiers on there and conditions that say, well, I'm valuing this, but this, I don't have this information. This is because that's worthless. And you just spent a bunch of money for no reason whatsoever. So I think it's important to make sure that for this expert to give you the opinion that you're asking for, that he or she be provided with all the documentation that they feel necessary to come up with that opinion.
And right on cue, that's a great place to ask a question that Joanne Bernanke has asked. Joanne asks, what are the documents or what is the information that you would need to get to an expert for valuation? She suggested things like bylaws and corporate documents, profit and loss statements, bank statements, tax returns. Is there anything else in addition to that non-exhaustive list that you'd recommend getting to your expert for valuation? And I'll open the floor to both of you for that.
Well, I'll jump in here if Louis doesn't mind, and I'll take the first stab at it. But I think that, the corporate governance documents, and I say corporate, it could be LLC operating agreement, it could be a partnership agreement, but the company governance documents really only come into play when you're talking about a management situation. I think when we're talking about who has management control for discounting purposes. For valuation purposes, you're really looking at financial statements, you're looking at the wage statements, et cetera. I mean, one of the things that I've really had a hard time understanding is getting involved in family law cases when I've been corporate counsel, and people questioning valuations based on audited financial statements from reputable accounting firms. And I kind of scratch my head and say, well, it's a different firm that's going to value the company, but they're looking in large part on audited financial statements, which a CPA firm is now putting their license and reputation on the line for. And so if you don't have audited financials, I can understand that, there's always going to be subject to some interpretation. But if you ever have audited financial statements, that's the place to start. And then I think you go from there. I think the harder question, and Louis can maybe speak to this better than I can, but the harder question is not so much valuing past or current value, it's future performance. What kind of value, what kind of number do you put on the business over the next 3 to 5 years? I think that's difficult when, especially if you have a new business or you have a business that has it's somewhat up and down in their revenue. So that's one that gets a little trickier. And I'm not sure that there's any particular document that you can deliver for that. So I think it's financial statements and other financial documents. Obviously, the bank accounts, the tax returns, the K1s, if it's an S corporate partnership or an LLC, all those documents would be something that you would start with.
Including audited documents, especially.
Audited if they have them. If they have audited financials, that's the first place to start.
Very good. Louis, before we go to control of business, is there anything you wanted to add to what Roger just said?
Yeah, two things. The real important is the inventory of work to be done, the accounts receivable, projected accounts receivable, and obviously the accounts payable, because of the obvious reason of you could be making a lot of money, but you're actually obligated to a lot of liabilities. The one thing that I did want to add to that I don't want to miss is the question that Mark I think alluded to of the valuation of a personal services business, which really most businesses are. And it goes to the valuation. That's why I think we can discuss it here is the more that a particular company is identified with a particular person or yeah, let's just say person, that talks to goodwill. And goodwill is that mysterious, ephemeral thing that is out there that a lot of experts purport to be able to tag a number to. And I think that it is fantasy. And just that is one thing that you have to be that as a dissolution attorney, whether it's for a business or a family law dissolution, you have to be careful, specifically depending on which side you are, that we don't get an overinflated or an underinflated value with regard to the value that that particular individual brings to that particular business. A perfect example would be a very small firm like my firm. My firm is worth, let's say, X number of dollars as long as I'm running it. But if I was to go and have a heart attack tomorrow, my two associates would go and find work elsewhere. And the people that I have assigned to close things down in that event would be selling these used law books that you have back there, essentially. And that's what my business is worth when I'm no longer associated with it. And then that, of course, is different for bigger firms, whether they're law firms or any other kind of business. Sometimes that gets sticky. I'm in a situation where we're taking care of that right now. I'm done.
Very good. So in the next topic, we're going to talk a little bit about control of the business. And I want to ask one of the questions that we got from one of our attendees. This question comes from Chris Rugard, and Chris asks, in essence, what is the best way for control to shift control in a non-certificated corporation or company from one spouse to the other to shift control if it is a corporation without certificates? And Roger, maybe you could talk a little bit about, you have certificated corporations and non, and kind of if there's a difference in terms of just getting the equity over. And then from there, we're going to talk a little bit about some of the considerations with respect to control, but perhaps you could address the issue of transferring shares.
Well, again, whether it's certificated, first of all, you can always create certificates. You can create certificates and you can adopt those as the certificates because they were never prepared, they were lost, stolen, or destroyed, etc. So that's not difficult if you want certificated rather shares. If you're in an S corporation, an LLC, or a partnership, the ownership interest will be established via the K-1s and the tax return. So you can always determine exactly whose interest was at least reported to the IRS and FTB. But in terms of transferring those, you can always do some type of a buy-sell agreement or just a share purchase or sale agreement where the shares are being transferred with what we call an assignment separate from certificate, which basically assigns all right, title, and interest in that equity interest to the other spouse in the absence of a certificate if you don't have one. So that's very easily done. And obviously, typically LLCs and partnerships don't have certificates, and that's how we handle it that way. I've seen a lot of smaller family-owned businesses never get around to certificating their interest either. But again, that's an easy problem to solve.
Okay. And Louis, I know that on the family law side of things, obviously one of the probably the primary concern, I would say, for a married couple who are litigants in a dissolution action who own a business is what to do with the control of the business. If you have, and Roger touched on this, and both of you did a little bit earlier on, if you've got both of the spouses involved in the business and the management or employment of the business versus one in, one out. But I suppose one of the considerations you have to make is, can the parties still work together if they're still involved in the business? Do you have any recommendations on that, or what's your? I would recommend that they not, but what's your take on that?
So I've been fortunate enough to see several iterations of what you just spoke about. Although I was not involved in the divorce, I am familiar with a fairly successful transportation business. And a husband and wife started this when they were sweethearts, and they're now, well, they're now divorced, but now they're well into their 80s and retired. And they got divorced about 20 years ago, and they ran this very, very successful thing even after they got divorced. I was in I handled a divorce a few years back where it was a smaller business, but still it supported the family. And the business almost went bankrupt because of the emotions of husband and wife in attempting to take care of this business and the distrust that was going on there. It's the good old lawyerly answer. It depends on how the parties are going to get along. Although my default would be, if you're the attorney and you see something where they're leading to destruction, my advice to my client in a situation like that would be either we eject the other one from the business, or we eject ourselves from the business, depending on what my client's goals are. That could be very detrimental for the business, and a lot of times these businesses are what is supporting the family and its lifestyle. So it's very important for us to be cognizant of protecting that asset.
And Roger, we started off talking about kind of post litigation, how we would kind of divvy up control, and Louis kind of took us during litigation. Let me ask you this: is it ever a good idea as an attorney representing a business where the husband and wife that are the owners or the shareholders, as it were, in the business are divorcing, perhaps to recommend a receiver or some other type of outside control of the business?
Well, the corporation's code, again, let's assume we have a situation where we have the spouses are equal owners in the company and equal, that they're both on the board of directors. And so now you have a 2-person board, which is what's required when you have 2 shareholders, and they are at odds. The corporation's code does have a mechanism where that you can overcome that dispute and that impasse by applying to the court for a neutral director who can be appointed if you can't agree on one. If they can agree on one, great, that makes that decision. That would be the less expensive, and figure out a way how that's going to happen. If they can't, then you can one or both of the spouses can apply to the court to have a neutral director appointed. And there's a similar situation to be available by analogy for an LLC or partnership. The problem with going in and trying to have a receiver appointed is that receivers aren't cheap, and that the company ends up paying that receiver for his or her time that they're spending going through everything. And so this asset, which may be the single most valuable asset in the divorce, is now depleting month by month as that receiver's bills are getting paid. And the other thing is too with the receiver is, yes, they may come in and have knowledge of the business from a financial standpoint, but not necessarily from an industrial knowledge or industry knowledge standpoint. They don't have the contacts. They don't have the ability to make all the business decisions that need to be made in conjunction with those financial decisions. So that's a slippery slope, and I think that's sort of a course of last resort, in my opinion.
Well, let me ask this question to Louis before we move to the next subject, which we'll discuss misuse of business asset. I would imagine that's a pretty popular one for this crowd that we would all see a lot. But a question I have for you, Louis, is about future agreements of the parties concerning future management of a company following a dissolution, how it would be managed, or keeping someone else who perhaps, relinquishes their managerial role, keeping them, somehow involved. But what is it with respect to future agreements that you've seen, or is that something you've seen at all?
So I think we need to break that question up into two parts, because I believe you said after dissolution. So generally, after dissolution in the family law courts, notwithstanding any agreement that the parties may make with regard to management, ongoing management of the business, generally the family law court, I practice in a couple of different counties. I'm trying to see if there's been an exception, at least in my experience. And I don't recall of an exception where the judge wants or allows, or even where the parties want to have a joint management after the judgment is handed down. Generally, the judge awards the business to one of the spouses and offsets the business with the Ferrari that I spoke about. So no. Now, I conceivably, and I'll let Roger add to that, it can be conceivable where the parties might stipulate by agreement to have some sort of involvement with the business afterwards. I could certainly see that in a bigger business where there are shareholders, but at the small business level that I do, under several $1 million, I've not seen that.
Let me ask you,
Roger, do you have any?
Yeah, I was going to ask Roger, have you seen any agreements or contracts between divorcing spouses related to control of a business?
No, I haven't. But my recommendation would be that whichever spouse is not going to be involved in actively managing, and you come to some agreement, which spouse is going to manage it, and the other spouse takes somewhat of a passive role as an owner with some oversight, but not actively managing, because I think that's just a recipe for disaster. I mean, you'd be better off to sell the business at that point. I mean, again, I have no problem if one says, I'm just going to be a passive investor for the most part, and I'm going to have some veto power, maybe, as it were, on certain decisions in terms of incurring debt or salaries in excess of a certain amount, or distributions, et cetera, et cetera. And again, part of that will depend on S versus C, corp versus LLC versus partnership, in terms of the flexibility you can have concerning preferred ownership interest versus non-preferred, voting versus non-voting, types of preferences in terms of either liquidation preferences or dividend preferences or capital return. I mean, all of those things you can work into that difference. You have no such ability in an S corp. The only thing you can do is have voting and non-voting stock, but you can still come up with management agreement even in that situation.
Okay. I see we're a little short on time, so I'm going to kind of work through the next two subjects. The first subject is the misuse of business assets. Obviously, everyone here understands that there are fiduciary duties that the spouses owe to each other and to the business. So what we did here is we've cited a couple of the Corporations Code and Family Law Code sections, respectively, that talk about some of those fiduciary duties. But obviously, I think it suffices to say for this topic that you should not misuse business assets, and that misusing business assets by one spouse can obviously create liability, for that spouse and probably for the business potentially as well. Is that your understanding? I'll start with you, Roger, since this is more business focused, at least for right now.
Yeah, I don't want to get too deep into the weeds, but definitely, I mean, obviously, corporate officers, directors, shareholders, partners, LLC members, managers owe fiduciary duties to each other, which is basically the highest degree of good faith, et cetera. And any time that you would be raiding the corporate coffers, spending on the corporate credit card for personal use without the consent of the other, all those things would be a breach of that fiduciary duty. To the extent that you're actually taking money out of there, and that's deemed to be a distribution, if you're an S corp, that could be deemed to be, because it wasn't equal in terms of the ownership percentage, that could actually undermine your ability to continue your S corp status, and could end up having that S corp status revoked, which would have significant tax ramifications for the corporation and for the individuals. So obviously there are some concerns. One of the things I will say, and I hope we don't have any civil judges on here, because I don't want to insult or inflame anything, but I have found that when in a family law situation with a business, and we have situations where there are spouses both involved in the business, and one is misusing the corporate assets, the civil judges have been loath to step in lieu of the family law matter to make a ruling on the basis of corporate law in terms of whether or not that was appropriate and should be stopped via TRO, et cetera. Instead, they tend to defer to family law, which has a different fiduciary duty vis-a-vis the spouses themselves once the dissolution proceeding is put in play. Louis mentioned the automatic TROs that go into effect once the dissolution is filed.
Do you want to pick up right there, Louis, with respect to the misuse of business assets, if you've got one of those ATROS orders in place?
So I could not more fully agree with Roger with regard to the approach of really both sides of the bench. It is our job as attorneys in these situations to clearly be able to educate the judge on how the family law code, and just for since it's being recorded, I'll give you the four codes. Is 721, 1100, 2100, and 2102 define the fiduciary duties that spouses have to each other with regard to the specific thing that Roger and I are talking about, and how to bring in the corporation code that 16403, 16404, and 16503. I have found that it's a challenge to convince a family law judge that we do indeed have these fiduciary duties under the corporate code that are law that apply in the family law code, and why they apply in the family law code. It's a tall thing. It's a tall approach, but it can be done. It's just up to us to educate the judge. And I agree with Roger. Judges sometimes tend to be, quote, loath, unquote, to apply that remedy that sometimes is really needed.
And one thing, Mark, I would say to add to that is, I think that oftentimes it depends as well on how many shareholders you have. If you have 3 or 4 shareholders in a business and only one of them is going through a divorce, and maybe the spouse is the 3rd or 4th shareholder, well, then they have fiduciary duties separate and apart from those owed to their spouse to their other shareholders who may be fellow officers and or directors. And in that case, you probably have a more convincing argument as opposed to a situation where it's just the husband and wife who are owning the business together and going through the divorce.
Okay, very good. We're at our last topic, which is fitting because we've got about 2 minutes left. The tax implications of a buyout. So let's just assume here in this 1 hour, we've gone through, we've started a business, we've divorced the couple in the business, and there's a buyout. And I'll start with you, Louis, if you're comfortable with the topic. I noticed that attorneys are either comfortable with tax discussions or completely uncomfortable with tax. But Louis, what are some of the tax implications of a buyout from one spouse to another following a dissolution? Obviously, you've got capital gains. You may have some income. Can you speak to that?
I absolutely can, and I'll tell you what we do at our firm. We bring in either, depending on the case, we bring in a tax attorney or we bring in a CPA, and I have my clients consult with them. And here's why. Some transactions between spouses are not taxable. Some are taxable. And I practice business law and family law, and I am not, and I do not pretend to be a tax expert. That's why we have people that do those. That really is my answer.
It's a great answer. Roger, did you have anything you wanted to add to that?
No, because I know that the tax treatment is different once the business is the subject of a family law proceeding, and the tax treatment's different. So I agree with Louis. I would defer to their personal or the corporate CPA to advise on the tax implications of the division of the business or the buyout of one spouse or another.
Wonderful. Well, I think we got to most or all of our questions today, and I want to thank, of course, Louis for being here and Roger for being here also, and a special thank you to Marta for putting this together. Believe me, for all the credit I got, it's really Marta's. So thank you, all of you. If there are any other questions, we're happy to take those now, or if either of you, Louis or Roger, want to tell any war stories or address any hypotheticals or any other questions you have, then now would be the time. But I just want to thank everyone, and also I want to thank Ann and the bar and all the various family law section, the business law section, and the litigation section for co-sponsoring this. So with that, thank you. And if there are any other questions, we're happy to take those, but we appreciate everyone joining us.
So I'm happy to stay, Mark, for a little bit if any of the attendees have any questions that they think I might be able to answer. Thank you, and everybody else for helping out. Thank you, Marta. Thank you, Ann. Nice to meet you, Roger.
Likewise, I'm happy to stick around. The one thing I would just say is that there are two different worlds. There is the family law world and there's the corporate world, and oftentimes they are on collision courses, and you just need to understand the nuances of each and understand where they dovetail and where they diverge, and how you have to navigate your way in and out of those situations.
Very good. I don't see any other questions popping up at this time, so I'll turn it back over to you, Ann. And if there's anything I can do, then just let me know.
I think we're all good. I don't see any other questions either. So again, thank you, everyone, Louis, Roger, Mark, and Marta for this program. And everyone, have a great rest of your week.
Good, thank you.